Good afternoon and welcome on behalf of the Wagner Law Group. This is Steve Wilkes in our San Francisco office. Thank you for attending our webinar today. We're going to talk about some standards and criteria to consider when working with senior and elder investors. I'm going to set the background on it a little bit, talk about some priorities, some of the history of the regulatory and other guidance that's been issued, and then focus specifically on two new rules that will become effective on February 5th. And actually, that was the original reason we were going to do this webinar, to update you on some new FINRA rules coming into effect at the turn of the year. But as we prepared for it and thought about it, we remembered and realized how much guidance and how complex, really, the regulatory overlay is when it comes to senior investors and elderly investors. So we thought we would set the stage with some of the related topics, and then really lead into the updated FINRA rules that are coming into effect. Talk a little bit also about certifications and some things that are happening with legislation and enforcement, and then maybe some best practices, some things, some takeaways. So here we go. The obvious, why are we even having this conversation? Well, obviously, the population is aging. Every study you look at talks about the growth of the older population. Let's say that means a person who's 65 years or older, though in today's world, 70 and 75, we're young and vigorous and still in the workforce and perhaps investing and what have you. So the old benchmark of 65 maybe isn't as relevant as it used to be, but people still refer to it. All the statistics from the SEC studies, from FINRA, from the U.S. Department of Health and Human Services indicate that we're going to have a huge elderly population, maybe 1 in 5, 1 in 6 people over 65 by the year 2040. And the baby boomers, of course, are a big part of that. So there's a huge surge in the aging of the population. And for those of you that are listening, as financial advisors, whether you are a broker-dealer or a rep under, FINRA regulation, as a financial advisor, as an investment advisor, if you will, you have a very important fiduciary duty to, act in the client's best interest at all times. And there's an implied fiduciary duty, if you will, in the broker-dealer world for suitability and knowing your customers. That will may be elevated to a new fiduciary standard over the next year or two as the SEC becomes more engaged in the process again. But anyway, it's very important. And what this really means is that, financial service providers have a real responsibility and an obligation to kind of understand their clients in terms of the special needs they might have due to their age, or special needs they have because they have been aging and just getting getting older. And one of the things that, of course, we think about is diminished capacity. What happens when you're working with a client who maybe starts to lose their mental acuity or doesn't really have it? Maybe they're being puppeted or controlled by someone else. What does diminished capacity really mean? It's a reflection on their mental or cognitive condition that would impact their ability to make informed decisions. It can be dementia, it can be a lot of other things. Memory loss, just, a hard time analyzing and understanding data. So you'll pick this up, when talking with a client. They might be a little forgetful, maybe just hard to do simple calculations, or performing simple tasks, things like that. You might have to think about, as a financial professional, gee, do I have a responsibility to do something, or am I allowed to blindly follow the orders of this client if I'm concerned about it? And that's kind of a challenge, when you're not sure about their competency. What if you think that a client is being abused? Unfortunately, there are stories out there where clients are being bullied or pushed by children, spouses, brothers, sisters, you name it. It goes under, elder abuse, exploitation. What does that mean? And that would be where, someone intentionally does something, or, a purposeful act or omission, by a person that you're counting on, a person in a position of trust that could harm a client. And, this comes up in our world, of the financial services world, where there might be unauthorized use of resources. And this is pretty tough too. I think statistically, a lot of times people that are engaged in elder abuse are family members, and you might have to intervene. Where does that leave you as the financial advisor? So, it's really, really tough, I think, when you have to make this call. And regulators, I think over the years have been very focused more and more on these senior issues or older issues, with the idea that they need to protect older investors. And a lot of times this goes hand in hand with just retirement. So when you hear about the regulators talking about we're going to focus on retirement accounts, senior, elder accounts, they kind of merge together. They often go hand in hand. And the SEC, FINRA, the state securities regulators, the North American Securities Administrators Association, they've done a lot of stuff together. I'm going to point out several reports and studies during this talk, and point you to some resources near the end. There's a tremendous amount of guidance and studies and surveys and reports and what have you that kind of address this issue of how to deal with our elderly population, with seniors, and this would include, potential financial abuse of the elderly, and maybe even diminished mental capacity. I mean, the SEC has had a bunch of summits in the past with FINRA and the AARP, for example. So then you have to ask, well, gee, I mean, as an advisor, would I be held liable if someone says I'm abusing an elderly client in a financial point of view? I mean, I have certain fiduciary principles that are applicable to me in terms of the advice I give, but do they mean that I'm responsible for assessing a client's mental competence? That would be kind of a stretch. I mean, obviously, even a lot of the cases and examples we know of, where the SEC and FINRA is focused for the most part, tend to be based on actual fraud or suitability or failure to disclose, and the whole notion of getting into the area of whether or not you have a responsibility to be an armchair psychologist is still a little bit unknown, but I think it's a trend to be mindful of, and I think it's something that we'll see coming up in the future. There are a lot of laws in the states that deal with incompetency and abuse that people have to be aware of anyway. There's a lot of elder abuse statutes. But the question as to how this applies to an advisor, you would probably have to be captured due to some sort of fraud or deception in the context of, the Advisors Act or FINRA regulations. There is a Texas case that a lot of people like to cite, and the court said, I think this was a case back around the year 2000. It involved Edward Jones, the Edward Jones firm, and the court said basically that that they acknowledge the risk that a senior might not appreciate the significance of a stock transaction. This can happen, but they did not find any responsibility to determine the competence of the client, though they certainly do impose all the other duties. So I think the takeaway from that was, the court cases seem to say that a stockbroker's fiduciary obligation doesn't necessarily include the duty to ascertain mental competence. But that's all changing. And I think, a lot of people have said, well, gee, if I had been an advisor and not a broker-dealer with a different, for the fiduciary standard of care rather than suitability, would that have been different? But anyway, this is an evolving area. A lot of things are happening. We'll talk about it a little more, but it's good for firms to have policies and to be on guard for working with their clients and to be aware of this. Firms are, I think, becoming somewhat proactive and forward-thinking in terms of having specific policies and procedures and how to deal with clients, how to get the right account documents when they open up, training employees to look for red flags, and so on and so forth. So these are things, this is kind of the world we live in. With the aging population, there's a lot of things going on, and advisors, broker-dealers, service providers need to be aware of the potential duties and responsibilities and how to best serve the client and where the liabilities might be. Now, clearly, this is clearly an exam priority. The SEC examination priorities, and I think I have the, yeah, there it is. There's the link if you want to read it. It's a great piece to read, by the way. Where for 17, the year just ended, they identified, the Office of Compliance Inspections and Examinations, excuse me, at the SEC identified priorities. They wanted to look at certain practices or products or services that they felt, might present, heightened risk to investors or to the integrity of the markets overall. And, based on their input from the staff of the SEC, the policymakers, the enforcement division, the commissioners, and so on and so forth, they identified several areas for priority in the year 2017, and one of them is kind of a blend. They said they were going to focus on risks that were specific to the elderly and retiring. The elderly and retiring. So again, those things kind of go hand in hand. And specifically, what they said in there was that they were going to continue, a prior initiative called the Retire Initiative, where they're focusing on advisors and broker-dealers, just generally, with all the services that are offered to retirement accounts. And they're looking, at least for 2017, they said they were going to focus on the variable insurance and target date funds, and they also said they were very interested in cross trades, particularly in the fixed income security world. And then, they said, in the public realm, public pensions, just so many dollars and so many employees in our public pension system, at the state or other government level, they were going to continue to examine the advisors to those. I think they're very much focused on the pay-to-play and the conflict of interest from gifts, the politicization, if you will, of some of the relationships. So that's an area that they're very focused on. And they also identified senior investors. And they said, look, our seniors really rely on their investment portfolios to fund their retirement. They don't have these fixed, defined benefits that our parents and grandparents might have had. So we need to really focus on how they're interacting with investors and how they're, including their ability to identify when their clients are being, financial exploitation of seniors. And they're very focused on supervisory programs and controls that relate to any product or service directed at investors. And that's something that I know you've heard from me in other webinars, my colleagues when they speak, we've been talking a lot about process, procedure, documentation. That's the new era we're in right now. Having written policies to a more evolved level, having written procedures to a more evolved level, documenting and then implementing is really important. Also on the FINRA side, same thing for 2017. They published what they called their regulatory and examination priorities letter. I have the link on there for you if you haven't already seen it. And they said, among other things, they were going to really focus on the sales practices that involve senior investors. They're very concerned about seniors being the subject of fraud and abuse, improper advice. They said they've seen a lot of cases and complaints where, reps have recommended that investors purchase, very speculative products in search of yield, in a low interest environment, or complex products in search of yield. And this is interesting. I mean, FINRA says, the quest for higher yield, looking for alpha, is not problematic per se, but it's a question of tracking it back and matching it, and whether it's saying it was suitable given that investor's profile, their needs, their risk tolerance, and whether there was good supervision in place to prevent, kind of systemic sales practices toward the seniors and the elderly that might be a problem. They also said that they were very focused on penny stocks. And just generally, they didn't identify seniors per se, but just generally, they continue as always. They're really looking at product suitability. And a lot of times that means, customers just don't understand, or the reps aren't properly trained. They just don't really understand the features of the product. So just the whole notion of how a firm vets a product beyond the platform and determines that it should be there and that it's okay for certain clients, how they train clients to sell those products. An area they're concerned with is because of the migration of reps from one firm to the other. Rep A goes to firm B. Rep A comes from a firm where they're very active in the alternative product marketplace. But firm A had a little more of a traditional menu. They don't really know how to manage and supervise these. So these are some of the things that they're really focused on. They're also looking at excess concentration in the accounts of seniors in a particular product, and they've identified long duration fixed income as an example. And this is from one of their sources of identifying this is, and I'll mention this a little later. FINRA did establish a Securities Helpline for seniors a while ago, kind of a dial in and ask for help. And they've had a lot of anecdotal information over the phone lines, about very speculative investments. A lot of them were energy-based or just complex, ETFs or, inverse ETFs, non-traded REITs, things like that. So the bottom line is I think it's pretty easy to assume and take for a given that the SEC and FINRA are very focused on the elderly and seniors for a variety of reasons. Now, as I indicated earlier when I started talking, the amount of work that has gone on over the last 10 or 15 years at the SEC, at FINRA, at the Association of Retired People, so on and so forth. I mean, there's a tremendous amount of guidance and work and studies out there. There's no law on the books that, with very few exceptions, that really says, here's the rule book, here's the section of the code or the regulation that deals with seniors. You have to piece together and make applicable fiduciary standards and suitability and know your customer and disclosure to kind of fine-tune them to seniors. But a lot of work has been going on, and I think one of the most important has been, it was published in 2015. I have the site there at the bottom for you. There are several places on the web you can find it. I have the FINRA site. It was called the National Senior Investor Initiative. And this is where the SEC's Office of Compliance Inspections and Examinations and FINRA, they got together. They examined 44 broker-dealers who I assume were identified to provide a broad sample base. And they looked at, a bunch of things we'll talk about in a minute. And it's a really, really great report. If you read that report and you go back and think about the policies and procedures at your own firm or how you conduct your business, you'll be in great shape. I mean, there's a tremendous amount of learning in there. They're really focused on products, on suitability, on training. That they found that not enough people had procedures for dealing with clients with diminished capacity. Not enough people had specific guidelines for seniors. So it's really, really helpful. It's a great map, if you will, to the kind of issues that they're looking at. And let me call out a few of them for you. It's pretty interesting. So they, I think the driver here was they recognized, in a downward yield market with low interest rates, the pressure on conservative income-producing investments makes it logical to think about seeking more alpha, logical to look for other sources of income to maintain income streams. But there's a lot of risk there with seniors, as you know. And I would just say, by way of background, this investment initiative came together, but there have been some other really good ones before it. In 2007, the SEC and the North American Securities Administration Association worked with FINRA's predecessor and the New York Stock Exchange on a bunch of education products. They issued a bunch of reports in 2007 and 2008. And in 2010, they published an addendum to update the prior reports. I have a lot of those sites for you to read, and they really come through with a lot of positive steps and things to focus on. And we have a series of notices from FINRA, which I'll mention, on advising seniors and the use of senior credentials and what have you that are really helpful, and you'll see reference to those too. So basically, let me just quickly run through this National Senior Investor Initiative. The staff met with regulators from various states, people at the AARP, FINRA, the SEC, the Consumer Financial Protection Bureau, and they focused on a couple of things. Number one, they focused on the actual securities that were purchased by seniors. and they identified all kinds of investments. They identified mutual funds and variable annuities and equities as the most common. There were a lot of complex securities such as REITs and UITs and structured products, but less frequent. And they did take away the sense that senior investors had fairly good disclosure on these and pretty good discussion on the potential return and associated risks. They focused on training. They wanted to know what firms were doing. I mean, you know, FINRA requires that broker-dealers provide continuing education to the reps, their representatives, this would have to cover, you know, securities recommendations and investment strategies and what have you. There's nothing that says a firm's training must address seniors per se, but that's a pretty good takeaway. And they found that a lot of firms had seniors training. They found that there was maybe a failure of firms to update information. In other words, the initial account opening with seniors gathered pretty good data, but there was a failure to escalate and update the data, you know, 5 or 6 years down the road as people aged, and that was something that they felt required more supervision. So they, you know, I think the takeaway there was to continue and just upgrade training of the seniors. I'll talk about senior designations a little later. They did focus at this point on senior designations, and regulatory notice 11-52 is a great outline for which really outlines, I think, the supervisory responsibilities for how to use senior designations, you know, where they suggest expertise or certification or specialty and some good practices to follow to supervise that. And they found, you know, back in 15, they found that that they think in terms of, you know, when you make a decision as to which designate, first of all, should you allow designations to be communicated at all? That's a gating factor. Some firms don't. Some firms just prohibit the use of that. Some firms that do say, okay, you can do it, but a supervisor has to approve, and other firms have more elaborate procedures where they say, we have to approve and we have some criteria. We need to know that your designation has a verified curriculum and an accreditation from a recognized independent institution that we really think is a valid one. It can't be self-schooled. They focus on marketing and communications. You know, FINRA requires, has various requirements for communications to the public, including, you know, retail communications. They have to be based on, you know, they have to be fair and in good faith and no exaggerations. Can't hide stuff in footnotes. Have to be clear, not misleading. There's some requirements around performance. There's some requirements about public appearances, what you say when you're giving speeches or being interviewed on the radio. And as you also know, there's a record-keeping requirement, I think, under the, what is it, Rule 17A, 17A4, under the Securities and Exchange Act, says that you have to preserve all your communications. They focused on that. And they, you know, they found in this report a lot of diverse approaches to seniors. They found a lot of specialized promotions that went out to seniors, some special retail communications. They found some product-focused themes on long-term insurance and wealth transfer, estate planning, you know, retirement seminars as a way to gather in the seniors. And, you know, at the end of the day, you know, they noted that, you know, senior in and of itself was not the dominant theme. It always seemed to focus around retirement planning. So it's just, you know, just very important to make sure, just as FINRA requires, that you've got good written supervisory procedures that have some sort of process in place, you know, where you're, whether you're in a scripted or unscripted communication or public appearance, there should be some review and process over that. And another thing they noted was that I think it's really helpful to require attendee evaluation forms to be given back so the firm can get a sense from the potential or existing clients about the quality of the information that's being provided. Account documentation was a big area. I mentioned before that they found that firms were pretty diligent in terms of opening accounts, but not that good in maintaining and updating the age, the health, the status of the client. So I think the takeaway there was, you know, more detailed information is good. Probably need to get some more. and a little better job of calculating both the immediate snapshot of what the client looks like on account opening, but projecting out the expenses and needs of the client, 4 or 5 years down the road, and then updating that as they age. And maybe having some sort of technology or automated alert to show when a customer is in need of updating the account, or maybe they self-report a change that triggers a review. Suitability, I mean, obviously that's a huge factor in this report, and they looked at the suitability of recommendations that were made around, variable annuities, alternatives, traditional mutual funds, some structured products, and they looked at, the exchanges, the fees, concentration of liquid net worth was a big issue they were concerned about, very short time horizons and age, and, they found some room for improvement. They found that even though most firms made suitable recommendations, I think they said it was around 10% they found were unsuitable recommendations because of the age. And some of that involved, structured notes and things that didn't have liquidity or just had very complex risks and, a default risk, very hard to value, and they just didn't really match it properly to the, to the investor. So again, in a low interest rate environment like we've had now, where you're trying to work with your clients and help them, get some yield, it's logical. It's tempting. You can see why firms are recommending, I'll call them non-traditional investments to supplement these income streams. But the SEC and FINRA are really very much aware of this, and they're looking very carefully at it. And it's just an area to be careful about when working with senior clients, and to make sure that you have good processes and procedures in place that match the suitability of these products, and maybe keeping good files, good documents, good acknowledgments from the client that they understand the risks, and also thinking about the product concentration guidelines that might make sense for seniors. They also talked quite a bit about disclosures. They focused on customer complaints. You might recall that the Exchange Act requires, firms to, record complaints that come in, and to keep files in every OSJ of written complaints. And also to remember that a complaint means any grievance involving, the activities, with the firm around a transaction. They get a lot of learning from these complaints. One of the things they noted was the complaints aren't always coded and matched to the age of the complainer. They felt that was something that would really be helpful. And that was one of the big takeaways there, I think, just making sure that senior-related complaints should be coded as such, because that gives you the ability to develop better processes and procedures and what have you. Supervision, again, I mean, obviously supervising all these things, having the right policies and procedures is very important. So that was a very robust, very healthy report. There's a lot in there. Check it out. I put the link in for those of you that are kind of, thinking about the current status of your policies and procedures with regard to senior clients. That'll be a great resource for you. Now, that happened in 2015. I also want to talk about some of the other regulations that are out there, which will, taken as a whole, are all very helpful. So I think probably one of the seminal pieces of guidance came from FINRA was Notice 0743, and they talked about the firm's obligations relating to seniors. They talked about what they thought were some of the best practices, some suitability concerns, communicating with the public, designations. They talked a little bit about dealing with investors that have diminished capacity and occurrences of suspected abuse. They provided some practical tips as well. So I think you'll see that in this particular notice, 0743, they really they lay out a pretty good roadmap for good best practices and policies and procedures, which subsequent pieces of guidance like the initiative we just spoke about built upon. So again, they focused on, they understand that that even among the senior investors, there'll be some that have different risk profiles and different expectancies, different needs. They're going to vary. FINRA recognizes that there are no special rules really for seniors, per se. I mean, they're developing now, but at the time in 07 they didn't really have any per se. But they just felt that at the time they felt that suitability of recommendations and communications aimed at older investors were really the high issues, or the most critical issues back then. And I think that it's funny because even though there's nothing in the suitability rule that explicitly references age, or where you are in life or anything, but those are really important factors in suitability, and liquidity is really important. These are all common sense things for you to think about, but they're pretty well spelled out. So the kind of questions they called out in this notice, when you're thinking about suitability and liquidity, and you're dealing with an older client. Is your client employed? How much longer are they going to work? What are their primary expenses? Have they got through the mortgage and the college? Have they paid for the house and the college yet, or are they still working on it? What are the sources of income? Is it fixed income, or is it going to vary? How much do they need to really meet their fixed costs? How much have they saved for retirement, and how much of those assets are actually invested? How important is liquidity of these assets? What are their goals? And what's their health care situation look like? As we all know, a health event can crush a family or an individual on their savings plans and their retirement plans and their long-term financial status. So these are all things that I think go into suitability, which were called out at the time. And I think, again, FINRA made the point that a firm does not have an obligation to shield a client from risk if a client wants to take it, but they have an obligation to make sure that the risk is fully understood by the client, and that the product that's recommended kind of matches the risk. When you think about the risk, the cost, the benefits of the whole transaction. So again, seniors don't have to be risk averse per se. It's just that maybe because of the time horizon, there's certain products that just aren't going to work properly. So, and the FINRA really called out, they were products that have a withdrawal penalty, like on annuities, for example, and some private placements, getting out early of a real estate deal or a limited partnership. CDOs, complex structured products, mortgaging your home equity, getting a second for investment purposes, and just generally speaking, pulling down, your retirement savings, including early withdrawals to invest. Now, a lot of these are the subject of other FINRA rulemakings, but these are the kind of things, these are the kind of questions, these are the factors that they want you to be, to be thinking about with seniors. Senior designations and credentials. There's a big discussion in this particular piece, which is very helpful about whether or not you are able to call yourself an advisor or a specialist or certified anything. There's some specific FINRA rules and also some state rules on this stuff that need to be coordinated. I would also remind you that they targeted back in 07, in this one in 0743, they targeted high-pressure sales seminars, the free lunch, free dinner, where people come in and get usually a wholesaler or someone will sponsor a dinner, and the advisors get up and they're pitching away. And there's nothing wrong with it. Please don't hear me as sounding as though I'm criticizing or demeaning that in any way. It's all part of the business of communicating with clients and raising assets. But they've identified, there have been examples of the free lunch seminar that can be high pressure, and those are not countenanced by FINRA or the SEC, and they're just deemed to be a very troubling sales practice, kind of misleading, just inherently false, because then you're also preying a little bit perhaps on the older people. Sometimes they're not as financially sophisticated, they're starting to get a little forgetful, maybe a little bit diminished capacity. It's hard for you to tell as the advisor, but maybe they were there with a caregiver and someone's helping them make decisions. It's just prone for trouble. So the things that they suggest that you look for when you're working with these accounts, ask them, is there a specific individual that you want to always come with you to the meetings or has the power to sign for you? Ask your firm what their published policies and published guidance is on seniors. Does your firm designate within the compliance department or legal department someone who's, quote, the senior person or the, quote, the elder person, with someone to really monitor that stuff? This is all really helpful. It's all spelled out. And, of course, the firms really need to be training their reps on this stuff and in terms of how, how to gather information for account opening and to work with the seniors and what have you. So that FINRA Notice 07-43 is very powerful, and it really is kind of the grand person, the granddaddy, if you will, of a lot of the practices and procedures and criteria that we built on going forward. Just some other examples. Again, there's so much out there. The states adopted a model, the NASAA adopted a model act to protect seniors and vulnerable adults back about a year ago. It's really pretty cool. I think it's called, the name of it is called Legislation to Protect Vulnerable, an Act to Protect Vulnerable Adults from Financial Exploitation. It mandates reporting either to your securities regulator or maybe even protective services if you think that one of your clients is being exploited. It authorizes, it creates a vehicle and authorizes notification to third parties, maybe in light of some of the privacy rules that are in play. It talks about delay of disbursements from an account if you think something is fishy. This model act provides immunity for the broker-dealer or the advisor for taking these kind of actions if they're followed through under this act. And there's a certain record-keeping requirement, record-keeping requirement that you would have for dealing with older. So it's a good model. Some states have followed it or done some things like it. The Model Act applies to adults that are 65 and older, or to individuals who, otherwise, might meet the definition of being a qualified individual. I mean, they would get some sort of protection under a state adult, protective services statute because of their age or mental capacity or what have you. So, and it was interesting. I think just a couple of months ago, there's a lot going on at the state level. There was a survey released back in the fall, which was conducted by the NASAA. It was a survey of state securities regulators, coming with some findings on financial fraud among the elderly and stuff. And yeah, they say it's out there. I think one of the biggest concerns that they're finding out about it too late, and it's going undetected rather than being discovered up front. So they're looking for more, again, more aggressive, more progressive action, affirmative action from the financial service community and from the regulations themselves. So that's a great source. Take a look at that model rule there. It's really terrific, very helpful for you. Now, there's so many other things going on I can't begin to tell you. So just to give you some examples, so FINRA put out a report in 2015 on some senior issues, and they implemented a Securities Helpline. It's a toll-free number that investors can call, or you could call to ask them how to deal maybe with an elderly client. And they're getting a lot of calls, and they've actually gotten a lot of voluntary reimbursements to help clients out that perhaps were wronged. And this report actually, continues to build on, and it shows areas for internal control that might be considered, back at your firm in terms of suitability and product offerings and training and what have you. There's also, the SEC put out with the CFPB, that's the Consumer Financial Protection Bureau, they put out some really great bulletins. The SEC puts out some really good materials where they talk about telling investors to think about diminished financial capacity as you get older, to plan for the day when you might be a little fuzzy and you need a friend that you can trust to help you deal with your investments, just with the right paperwork, having a power of attorney or what have you. But these are things that are all that you're seeing yourself as the advisor at the RIA or the broker-dealer firm. So these are areas of activity that are going on. I spoke a little before about Notice 1152. This is the certification and designation. It's a great read. What they did was, they as I told you before, they had mentioned back in Regulatory Notice 0743. This is one of the topics that they came up with, and they built on it in subsequent reports in 08 and 10 and began to put it into their annual priorities starting, I think, in 2011. So there's a lot going on here, and senior designations is part of it. And in 2011, I guess they took a survey of about 157 firms, and these firms, I'm sure, were statistically selected to get a good cross-section, you know, of size and geography and the business models and what have you. So they found a lot of senior designations out there. They found that at least of the firms that they surveyed, 68% said that they allowed senior designations to be used by their reps. Of that 68%, about 90% had registered persons who use senior designations, and 11% don't have any, don't even allow it to happen. So there are varying levels. I mean, some firms said that we just don't allow it at all. Some firms said we don't acquire approval, we don't verify credentials, we do allow it. Some firms said we not only require approval, we verify credentials, you have to make an annual attestation. You know, there's a couple of ways to go there. So I think there's some different practices that one could follow in terms of the use of these certifications and designations. So I think the things that help support certifications and designations are where the certification or designation comes from a program or a third party or a curriculum that's really rigorous and well developed, discusses ethics and fiduciary type standards. It has maybe ongoing requirements. It's not a one-time license. That there's a way maybe to determine independently that the person's in good standing as compared to self-reporting. And maybe there's even a disciplinary process for failure to satisfy those standards. You need to really focus on how you're communicating with your clients about these certifications, you know, to prevent falsehoods. You know, you don't want, you know, inflated resumes, so to speak, for lack of a better term. Training, you know, you want a firm should be able to represent that that its people have had training in retirement planning and ethics, and that's part of the certification license they've earned. And also, you know, there should be annual attestations, like I said before. So those are some of the things you want to think about. 11-52 is a great segue into like looking at your credentialing process. You know, what credentials are allowed, who can use them, how do we supervise it, how do we monitor it. Now, I'm going to get to what I had originally thought about when I thought about this webinar, which is what's happening in February. And then it expanded when we just reminded ourselves how much is out there with the elderly. So basically, FINRA Notice 1711, you know, it's been around for a while, but what's really happened is that the SEC has finally approved, you know, two FINRA rules. One's an amendment and one is a new rule. The amendment is on Rule 4512. This is with customer account information. And remember, this comes live on in February. And remember, you know, this is where let me see. The rule says that you have to make reasonable efforts to obtain the name of and contact information for a trusted contact person for a customer's account. And then there's a new rule which involves financial exploitation of certain adults, which permit members to put a hold on disbursements of funds or securities where there's a reasonable belief of financial exploitation of these customers. So these are coming effective on February 5th. I know we've been thinking about them and talking about them for a while, but now we're getting down to the jump-off point. And I think they're going to help, really, they're going to help firms deal with troubled situations. Let me give you a little more detail on it. In terms of the amendment, the trusted contact person, you know, Rule 4512 gives you the specific account information that you have to obtain, and the amendment says that when opening, you know, a non-institutional account or an updating an account of a non-institutional customer, members have to make reasonable efforts to get the name and contact information of a trusted contact person, someone 18 or older. And when you're opening this account, you have to disclose to the customer in writing that your rep, you know, that the firm, you know, the member, is authorized to contact this trusted contact person and disclose certain information for the purposes of addressing potential exploitation, in other words, to help them. And that might be so much as to confirm their health status or the identity of their trustee or power of attorney or what have you. And you have to make this disclosure even if the customer fails to identify a trusted contact. So that's part of the new account opening. And also, Rule 2165, temporary hold on disbursements. There's kind of a limited safe harbor for a temporary hold of from the account of a specified adult customer. If the rep thinks or the firm thinks that, reasonably thinks, I should say, that financial exploitation has occurred, or it might happen, or it has happened in the past. So the people that are covered by this, the client has to be 65 and older, or anyone who's 18 or older, who you reasonably believe has a mental or physical impairment that makes you unable to protect your own interests. Remember I was saying earlier on how you're becoming an armchair psychologist? Well, here you are. You're going to be in that position where you have to maybe judge the competency of your, or be thinking about judging the competency. So you're going to need some good guidelines and some good supervision here from the firm, how to do it. So this temporary hold can go onto an account. It can only go with regard to a specific, disbursement, not the entire account, if you will. And the account is the hold is limited to disbursements and not to security transactions. So the FINRA has defined exploitation pretty broadly, and your common sense would tell you the wrongful or unauthorized taking or misuse or appropriation of an adult's funds or securities, or any act or failure to act regarding an adult, to obtain control, with deception, intimidation, undue influence, or improper conversion of their assets. So then there's some other rules, there's certain requirements that come into place about, you have to, if you do this, you have to conduct an internal review immediately. You have to notify the customer within 2 business days. You have to retain evidence, and so on and so forth. So, and then there's some record-keeping requirements about it. So it's coming into effect as we speak, and obviously there's a supervision and compliance requirement as well, and you're going to have supervision and compliance with regard to this new temporary hold provision as well. You have to have procedures that talk about identifying and escalating and reporting matters involved here, the identification of every person that's involved, and you have to have training to make sure that you can implement this policy, and that's all be documented. So that's a lot. It's a little bit tricky. I know you've had a chance to be thinking about it for a while. Those are things that are coming up in February. So for those of you that have fallen behind or haven't quite stayed abreast with it, you still have a little bit of time to pull it together. Now, I think I would just say in terms of legislation and enforcement, and given the time here, I don't want to run too much longer. A lot of states have either adopted the Model Act I talked about before, or provisions of it. You're going to find some special rules about financial exploitation of seniors and the elderly in a lot of states right now. You need to be aware of what state you're practicing in to see and as to whether or not it's applicable to you. On the enforcement side, I can tell you for a fact, I just a couple of days ago I pulled this. I thought it was kind of funny. The SEC they charged a Florida operator with a penny stock violation. It involved an entertainment company and a product called the Sponge Buddy. I asked some of the younger kids I know if they know who Sponge Buddy is. They looked at me with blank stares. I think that's a popular toy or video game at the moment. I'm not exactly sure. But the focus of the SEC identified, millions of dollars were taken from some elderly investors. So they kind of came down on them under the notion of we're protecting our senior and our elder investors. Penny stock is something we're looking at. That's an example. Just a couple of days ago in Massachusetts, an advisor was charged with stealing $9 million from an elderly client's foundation. And the SEC, they charged a New York-based advisor. This involved a transaction in Massachusetts, the charitable foundation. But again, they were on this. It somehow came up, somehow tweaked up under the rubric of we're protecting the elderly and the seniors. So you can be assured that at the state and the federal level, they're looking at financial exploitation and seniors as a protected class, and there'll be a lot of emphasis there. So it's time to really give pause to how all these other rules we have, fiduciary standards, know your customer, suitability, disclosure, credentialing, record keeping, documenting, account opening, how they play to different audiences, including the elderly. So just a few takeaways here. I mean, in terms of best practices, there are a lot of things that we can do. I think one thing you want to have a policy where you wanted to be able to define who these classes are. How do you define elderly at your firm or senior? How do you define a cognitive issue? What are the red flags you look for? How do you monitor these accounts? What do you do in the event something happens? What's your action plan? How are you training people? How are you dealing with titles and certifications? What does the account opening process look like in terms of trusted advisors, powers of attorney? Rethinking suitability and disclosures in the context of the special needs of older clients. So I think, I mean, when you think about it, so I mean, to me the logic is you have to kind of define who your senior or your vulnerable investors are. Do you have policies and procedures to identify them? How do you define them? How do you train people to define them? How do you identify red flags that would give cause to you thinking someone might be vulnerable? How do you detect financial exploitation? There could be a run in someone's account, a lot of cash withdrawals, or they're making some unsolicited trades or things that look kind of crazy to you. How do you report it? I mean, there are some states there might be mandatory reporting. In other states it could be voluntary. In other states it might not exist at all. Should there be reporting at least internally in the firm? How do we monitor it internally? Do we notify any third parties? Do we have people with powers of attorney or family members? And how do we do so? Are there any privacy laws that we need to coordinate with or around? Now you have your disbursements. We started with the new FINRA rule, the safe harbor for disbursement. So I think these are the things that we need to be thinking about that will translate into best practices going forward for dealing with this client base. We've worked with a lot of our clients on either compliance manual or WSP on bolstering and upgrading policies and procedures across this broad area, what we call retirement, senior, and elderly. So it's something that really needs to be done. Finally, I just want to end by telling you, I gave you back when we spoke about the National Senior Investor Initiative up front as being a big study that we have in 2015. I gave you the link for it. They have two appendices attached to it, one of which is Appendix A. And they had an incredible list of resources on there. They had the URL links to about 30 or 40 just incredibly good, either SEC or FINRA or NASAA, white papers, published guidance, official regulations, what have you. So I would encourage you just to go to pull the initiative and go to the appendix and pull that additional resource off there, because it'll really, really be helpful to you in terms of your training, your policies and procedures, meeting your standards of care, and what have you. So I just wanted to point that out and share that with you. We've just about come up on an hour. On behalf of my colleagues at the Wagner Law Group, I want to thank you very much for attending the webinar. I hope it was helpful and interesting for you in the near term for what you have to be doing in February, and in the larger scale of working with senior and elder investors. Who are they? How do you deal with them? What do you do? What are the things to look for? What are the policies and procedures you need? And if you have any follow-up questions on this webinar, my contact information is here, and you can you can give me a call or email me. I'd be glad to talk with you anytime. Thank you very much for attending. Have a good day.